We're on the record in two cases. The first case is cause number 325-707. And the second case is cause number 325-709. Both cases are styled the state of Texas versus Clay Autry III. And we have Mr. Clay Autry, who is appearing via Zoom. Mr. Autry, how are you doing?
Doing well, Judge. How are you doing, sir?
I'm doing fine. Thanks for asking. Mr. Autry, in this case, you are represented by your attorney, Mr. Adam Crawshaw. Mr. Crawshaw, how are you doing?
Doing great, Judge. Thank you.
Okay. And the state assistant district attorney in this case is Mr. Raymond Shearer. Mr. Shearer, he's in person in the courtroom. Mr. Shearer, how are you doing?
Doing quite well, Your Honor.
Okay. And again, Mr. Crawshaw, are you ready to proceed?
Yes, please.
And state, are you ready to proceed?
State's ready, Your Honor.
Okay, we have in each one of these cases, the court has before the motion to quash the complaint and information. Mr. Crawshaw, you may proceed.
Thank you, Judge. The reason we are seeking or have moved to quash the complaint and information is because simply the complaint is not sufficient as required by the Code of Criminal Procedure, and therefore the information based on an invalid complaint cannot be, is invalid as well. Specifically, Article 15.052, which is in my motion, states that the complaint, any information must be supported by a valid complaint, and the complaint must show a couple of things: that the accused has committed some offense against the laws of the state of Texas and it must show it one of two ways. Either one, directly via personal knowledge of the affiant, putting out or writing down facts that would show the offense alleged in the information, or two, by stating that the affiant has good reason to believe and does believe that the accused has committed such offense. So when we break that specific section down, we know by looking at the documents on file and with the court that the complaint does not say that the affiant has good reason to believe and does believe. I don't think there's any issue about that. So that leaves us with the complaint must show directly that the accused committed the offense with sufficient facts written down and sworn to within the personal knowledge of the affiant to set out the offense here of either driving while intoxicated or unlawful carrying of a weapon. And so when we scroll down onto page 2 of my motion, I point out in the Young case, it's Young versus State, that exactly what I've just explained and argued to the court. The complaint did not the person who signs the complaint and swears to what's alleged therein doesn't purport to have personal knowledge of the offense. So that person must then say, if they don't have personal knowledge, they must say they have good reason to believe and do believe. And we don't have either one of those things here in Autry's case in either 325-707, or 325-709. And so we are moving to quash the complaint and information for that reason. And I reserve a little bit of time, not much, probably, for rebuttal pursuant to Chapter 28.
State, you'd like to respond?
Yes, it would, Your Honor.
Let me do this here, Mr. Mr. Crawshaw. Can you hear him?
Yes.
Oh, you can? Okay.
If I can step up to the table.
Okay, that's fine.
Okay. Quite obviously, the state is in opposition to this complaint or motion to quash. And as Ms. Crawshaw has stated, the Code of Criminal Procedure, Article 15.05, and he's referring to paragraph 2 under that. The operative word there is or, and the state is alleging directly. Mr. Crawshaw has correctly stated that it's two different ways of doing it, either directly, or I guess you could call the other indirectly, because it's must show the accused has committed some offense against state, either directly or that the affiant has good reason to believe and does believe the accusation or the accused has committed such offense. And I must admit, it took some time to really find case on this because this is such old established law, and our complaints and informations are all identical. There's nothing missing from them. And the state would like to point out a case of Barry, B-A-R-R-Y versus state, and it's 387 Southwest 2D 663, and it's from the Court of Criminal Appeals. And on page 664 of that, the appellate was claiming there was no statement of facts, and the appellate contends that the complaint is insufficient because it does not set out that the affiant does believe that the appellate commit the offense. And we are not dealing with a does believe situation. We're dealing with a direct in the first one. And the complaint in this case is sufficient. The ruling goes on to say, because the allegation positively states that she committed the offense and is sufficient under the first part of Section 2 of Article 222 supra, it is not based on the allegation as in the Fowler case, which is the case that is cited in Mr. Crawshaw's brief, that the affiant had reason to believe, which made the allegations of does believe necessary. And the reference made in there, Section 2, Article 222, goes back to Vernon's statutes in 1948 that were published, in which the Article 222 has a paragraph 2 that says it must show that the accused has committed some offense against the state laws of this, or laws of the state, either directly or that the affiant has good reason to believe and does believe that the accused has committed such offense. So it's identical to our modern 15.05 in its wording. Further, the second option for showing is not applicable here. And I'm looking at Fowler State, cited by the defense counsel, that complaint upon the information is predicated recites that affiant has good reason to believe in charge. And they have repeatedly held that in the obedience to the provisions of Section 2, Article 222, which I pointed out is the same as 15.05, the affiant to the complaint must state, in addition to his having good reason to believe, that he does believe in the alleged offense has been committed. So if the state elects to not say has reason to believe or does believe, then we're going with the direct accusation. And the state would also like to point out in the Texas practice, criminal practice and procedures, Section 24.9, the third edition, in that the commentary on the complaint, the affirmed need not explicitly charge that the accused did the things constituting the offense. The complaint is sufficient if it alleges as fact those things constituting the offense. It goes on to say Article 15.02 of the Code of Criminal Procedure provides for two ways in which a complaint may show that the accused committed the offense. First, the complaint may assess directly that the accused committed the offense by using phraseology constituting an unqualified assertion. If this is done, it is sufficient itself. The complaint need not, for example, state that the complaint does believe or that the complaint has good reason to believe that what the complaint asserts is true. And then secondly is the complaint may show the accused guilty indirectly by stating the complaint has good reason to believe. So there's two different ways there. The state has chosen to file our complaints as a direct accusation, and in a direct accusation, and in the case here, Jessica Atwood, who is a trooper with the Texas Department of Public Safety, has signed the complaint. The complaint in both cases are sworn and then affixed to the information. And the wording in both the complaint and the information, I believe Mr. Crawshaw's says that both the complaint and the information are identical, although the body and the text involved is pretty much the same. I think it's worth pointing out that the complaint itself is a sworn document, whereas the information is the information itself. The state feels like this complaint and information process that we've used probably decades, over thousands of cases, is correct and proper under law.
Are you finished?
Yes, Your Honor.
Okay, Mr. Crawshaw, want to respond?
Judge, if, kind of working backwards here, if the complaint need not be anything different than the information, I don't think the legislature would require it. In the case law that I've cited, and it's made clear that in the cases that Mr. Shearer points out too, it's made clear that if it's not going to be done by stating that the affiant has reason to believe and does believe, then it needs to be done based on direct statements within the personal knowledge of the affiant. And we don't have that here. And the personal knowledge contention is found in the case law that I've cited and also in the case law that Mr. Shearer cited. In the Berry case, in looking at that opinion, I can read it to you because it is a short opinion, like many of them that time. It says that Berry, the appellant, contended that the complaint was insufficient because it doesn't set out the affiant does believe or has reason to believe. And they said that it's sufficient because the allegation positively states that that she committed the offense. However, I don't know what the complaint in that case said or why it was sufficient because it said directly. The case law that I've cited to says quite clearly, I think, that if it's going to be a direct accusation, it needs to set forth facts within the personal knowledge of the affiant. And we don't have that here. I'm not saying, and again, I'm not saying that Mr. Autry can't be charged with this. But I don't think that the Berry opinion stands for the rule that you can have the same content in a complaint as you can in an information, and that'd be okay. Otherwise, we wouldn't have a second statutory requirement for a complaint. We could just invoke the jurisdiction. We could just invoke the jurisdiction of a county court at law by filing an information. Thank you.
Okay, Mr. Shearer.
Well, you know, the legislative intent behind this is beyond the decision of this court, but the fact of the matter is, it does say that information needs to be supported by a complaint. And in this case, the complaint and the information have one huge drastic difference, and that falls against below the line of against the peace and dignity of the state, in which we have Jessica Atwood, who is an affiant. And by the mere fact that she signed affiant on this as to the facts and circumstances above, shows that she has either knowledge or personal knowledge. And I don't see that personal knowledge is applicable because she is a trooper, and she's based off the statement from another trooper who actually made the arrest. So as a result, she doesn't have to go back and research this herself to have personal knowledge. That she does have knowledge, and her signing that she's swearing to the above statement is a direct accusation.
Oh, you finished?
Yes, sir.
Okay, Mr. Crawshaw? You have anything else?
Yes, Judge, I think Mr. Shearer is correct, is that she doesn't have personal knowledge, which is why then it would need to be stated in the complaint that she has reason to believe and does believe, which is what the case law that I've cited to says. And the reason it's all very old case law is because it's all well settled law. And that's all.
Mr. Crawshaw, notice that you had cited is that the Golson case? Is that Golson versus State 667 Southwest Second 168? I think in that case, it says, let's see. I'm on page 3 of your motion.
Yes, sir.
I just started to stop says, well, let me see what it's, okay. And I think that's, you started that, on page 2, you started off with the Young case that you mentioned earlier.
Yes.
The affiant in the complaint did not purport to have personal knowledge of the offense. And while she asserts that she has good reason to believe such an offense occurred, she does not state that she does believe that the accused committed an offense. And then you went on, you said it was well settled, well established that the requirements that an affiant state that he or she does believe that an accused committed an offense is a statutory requirement, and its absence vitiates a complaint. And then you cited several cases: Young versus State, Barnes versus State, Bettle versus State, Wall versus State, Smith versus State. And then on page 3, at the top, it says that even in the case of an informant, the underlying complaint, which is judged by less stringent standards than the case of a felony complaint. And then you cite Well versus State, and then it goes on to say it is the complaint alone and not any other affidavits given in support of arrest or search warrants which determines the validity of the information. And then you cited, I think, Golson v. State, 667 Southwest Second 168, and also that case was citing Holland versus State, 623 Southwest Second 651. And my question is, because I looked at the brief while briefing, looking at the brief, I came across, well, I just had some questions. So is the requirements of the complaint, is that met in the probable cause affidavit?
No, sir.
Is not met in the probable cause affidavit?
No, sir. Now, there is a case that says that it can be. I wholly disagree with that case. That's the Caves versus State case. That's out of the Fourth Court of Appeals here in San Antonio.
Right.
But we have, but I don't think the Fourth Court overturns Golson v. State when it says that it's, and Wells versus State, which says that it's the complaint alone and not any other affidavits given in support of the arrest, which determines the validity of the information. And I I'm not aware of a probable cause, and if there is one, I apologize right now. I'm not aware of a probable cause affidavit being on file in the court file in this case.
Which file? Oh. And
This
let me see, I think, no, that Golson case was the Texas appellate case out of Houston, the 14th district. Is that correct?
Yes,
Okay. And I think you said, yeah, the Caves case. Was that, let's see. That was State versus Caves.
yes, sir.
Okay.
I didn't cite it. I did not cite that case in my motion, but the rules require me that you asked that question, and there's a case on point to that question. I don't like it at all, but I got to tell the court about it anyway.
Okay. He said, he didn't think there was a probable cause affidavit in the,
And which one of them? Both of them?
yeah, both of them.
It's 1325707.
Yeah, just print it off. So let me, just a quick question. Had you completed your discovery in this case? I noticed you said you didn't get a probable cause affidavit. Do y'all give, is that part of the discovery?
No, because it should normally is, Judge, but I don't think that the probable cause affidavit was filed in support of the information in this case. When the information is presented to the clerks to open a file procedurally, I don't think that there's a probable cause affidavit filed with the information in support of the information unless it's filed at large. In this case, there was no at-large charge.
Okay, I'm looking at, which one this one came out of? Which one came out of? It's identical.
Yes, Your Honor, it's,
Okay.
they were both charges, it's the same incident.
Okay, yeah, I'm looking at the information, and well, I guess you haven't, seen the information, so,
You mean the probable cause?
excuse me, the probable cause affidavit, excuse me, I have to say the information, but I'm looking at the probable cause affidavit, which you haven't, seen. And,
The thing is, sorry, let me know when it's my turn.
yeah, no, I was just trying to, I didn't want to go into it if you haven't seen it. That was my dilemma. Cause, so it's in the court's file, but,
But the state is not, we're not substitute. My argument there would be, and if I need to get a copy of it, then I could submit argument on that. We don't need to come back. But my argument would be is that when we get served with the copy of the complaint and information, that's what the complaint is there for. Now, I will agree with the contention that a probable cause affidavit can be used as a complaint if it contains all the other requisites.
okay.
But that does not mean that it is used as a complaint.
So you're saying you can't use a probable cause affidavit if there is a complaint? That's what you're saying?
You could, but that's not the complaint. In this case, it's the probable cause affidavit, and that's fine, but it's not being used to support the information. That's why the state filed the complaint with the information.
Okay, well, okay, State, you have a response?
I'm a little bit confused here because I'm not seeing what the relevance of the probable cause affidavit is in the first place, because the complaint clearly states that heretofore on or after December 6, 2019, lived in and near operate a motor vehicle in a public place in Jefferson County, Texas. So if he's trying to argue that the complaint is insufficient based on information placed in the complaint, I don't see that that's the case.
I think, you correct me if I'm wrong, Mr. Crawshaw. I think what he's saying is that, hold on a minute, I'm gonna just read his motion. Oh, here it is, right here, okay. I think what he's saying, and if I'm not mistaken, Mr. Crawshaw, under Article 15.05, Section 2, it reads, and we're talking about the requirements of the complaint. It must show that the accused has committed some offense against the laws of the state, either directly or that the affiant has good reason to believe and does believe that the accused has committed such offense. And I think what Mr. Crawshaw is saying is that he doesn't believe that the affiant, let me see, that the affiant has shown that the defendant has directly, well, doesn't have direct knowledge that the defendant committed an offense against the laws of the state, and, or we can say, or that the affiant did not state that the affiant had good reason to believe and does believe that the accused, in this case, Mr. Autry, has committed such offense. Mr. Crawshaw, is that basically what you're saying?
Yes.
Okay.
And it's the state's position that the affiant, Jessica Atwood, is directly accusing Clay Autry of the offense of driving while intoxicated, second offense. And this direct accusation is what we base our complaint on.
Okay. Anything else?
Yes, Judge, that if it's going to state it directly, it needs to be done with personal knowledge, and it's not here.
Your Honor, I don't find where it says anything about personal knowledge.
Okay, go ahead.
The premises under which law enforcement works is that officers routinely act on and carry out stops, seizures, arrests based on information provided by another officer. And personal knowledge, when you're talking about from law enforcement agency to law enforcement agency, I mean, they routinely stop and arrest people out of vehicles because another agency has entered that vehicle as stolen.
Okay.
So personal knowledge in this case is not.
Okay.
Sure. That's all well and good, but we're talking about charging instruments here, not law enforcement activities in the field.
Okay, let me ask this question. I got one for Mr. Shearer and then one for Mr. Crenshaw. Do you have a case that say that the affiant does not need personal knowledge?
No, Your Honor, that has not come up in the cases that I found, but I can find one.
Okay. Now, and Mr. Crawshaw, do you have a case that states that the affiant needs to have personal knowledge?
Yes, sir.
Okay.
That's what it's cited in my motion. Yes, is the answer.
Okay.
If they're going to charge it directly, which is what's being attempted here, they have to have personal knowledge.
Oh, that's the Young case that you, let me see, we'll see.
And the Fowler case.
Okay, Fowler. Yeah, okay. I was just looking at the, I know you said, I think you used the Fowler case and you just kind of incorporated Mr. Autry's name in there. When you say because the complaint in this case does not show directly that Mr. Autry committed some offense against the laws of the state, it must show that the affiant has good reason to believe and does believe that the accused has committed such offense. Okay, and that's he's citing the Fowler case as his authority on that.
Yes, sir. Judge, can I help the court with one thing on the Fowler case?
Okay.
That citation that I have there is correct, but that's the Southwestern Reporter. If you look that up in Westlaw or Lexis, it's kind of confusing because for some reason the court went back and forth on other non-relevant issues.
Okay.
So the best site to use if you're going to look it up is 156.
156.
Texas Crim or Tex Crim 267.
Okay, Texas Crim 267?
Yes, at 268.
Okay, at 268, okay, okay, 268. Okay. And do we have, Mr. Croshaw, you have anything else?
No, thank you.
And Mr. Shearer, do you have anything else?
No, Your Honor.
Okay, what the court is going to do, I'm going to take, first of all, I'm going to take judicial notice of the court's file, and I will also take this matter under advisement. And do we have a, Mr. Croshaw, do we have a court date set for this case?
I believe we have one in June.
Okay. Okay, I'll give you a ruling by our next court date.
Okay, that's
Okay.
fine, Judge. If
And,
the state, Mr. Shearer, we can go off the record if we need to. Don't need to make a sidebar while we're on the record.
Okay, I'll just go off, let me get off of YouTube. That's the case. So, let me do this. And just for the record, once we complete this hearing, both Mr. Clay Autry as well as Mr. Adam Croshaw, y'all will be free to go, and y'all will be excused, and y'all have a blessed day. And the same to you,